Good morning, friends. Today's topic is the confluence, interlink between the Income Tax Act and various other important related laws, namely the Money Laundering Act, the Benami Act, and the Black Monies Act. All these three acts arise and spring from a very important source, namely the Income Tax Act itself. Therefore, it is the mother of all statutes, and these are the tributaries, because whenever there is something which is lacking in these acts, you immediately come to the parent act, that is the Income Tax Act. One thing common in all these acts is that they all relate to economic offenses. They are all Economic Offenses Act connected with the Income Tax Act. There is interconnection. In Benami, almost all the references are made to the Income Tax Act. The Black Money Act is an offshoot of the Income Tax Act to make a more specific act on black money stashed abroad. And the Money Laundering Act is another act which has schedule of offenses, proceeds of crime, and has a direct link and connection with the Income Tax Act. We will analyze all these three interconnections and issues. But first, let me start with the Black Monies Act. I will first deal in the Black Monies Act few important issues. The first one, which I'm dealing with, is, you know, this is the time of a pandemic. There is a big problem that COVID has engulfed the entire world. At any point of time, the World Health Organization has made it clear that 1/3 of the world continues to be in lockout. And a greater problem is that almost 14 million people will be on the verge of starvation by the end of the year if the pandemic continues. In this position of lockdown, a question arose: how does the government cope with it? The government introduced the lockdown, a very good step taken and on a very timely basis, but that brought about various activities, including the income tax activities, to a standstill. Because of the COVID implications and the lockout, the concomitant event that arose in the first instance is that certain compliances which were required to be made could not be made. In this connection, I will first start with the position which came by way of a press note on 24/2/2020. In this press note, the government pointed out that certain acts which were there, especially the Income Tax Act, the time limit for compliances, due date of returns, etc., reply to notices, etc., reopening and other things are extended from the deadline of 31st March to 30th June. So the press note of 24/3/2020 extended the first time limit up to 36 2020. However, as you know, the COVID continued. And when it continued in this way, it was still difficult to go ahead for the compliance. The former was a press note, so the government thereafter, on 24/6/2020, came out with an ordinance. The ordinance, Taxation and Other Acts, simplification, rationalization of relevant provisions, ordinance of 2020. This is the ordinance which I'm referring to, is 2 of 220. And this ordinance refers to certain specified acts. Specified acts as contemplated included Wealth Tax, Income Tax Act, Benami transactions, Benami Act. It also included the Black Monies Act, Section 68, 69, Finance Act, etc. But one important observation is that the Money Laundering Act is not mentioned there. So the extension by the Ordinance 2 of 20 does not mention the extension qua the Money Laundering Act. Section 3 of the said ordinance again points out that there would be an extension. There are 3 important points which I'll just bring it to your attention. The first is the word end date. So it is given as an end date. What is the date? Second is the specified acts. The various acts are specified. And finally, one very important point is that it is for the purposes of completion and compliance. So the compliance is very important, and completion. So now what is done? That everything up to 31/12/2020 has been extended up to 31/3/2021. And this extension applies both to the assessee as well as to the department. So the point that I'm making, one peculiarity of this ordinance is that you have this extension which is applicable to both the assessee and the department. It is not on the basis of only one particular department, but for both of the department and the assessee together, the date specified is up to 31/3/2021. The second point after the extension I want to deal with is Section 149 of the Income Tax Act. 149 deals with time limit. Attention I'm inviting is on 149(1)(c), where it is made very clear that by the Finance Act of 2012, the time period for assets located outside India for the purposes of reopening, the income arising from such assets on the question of reopening more than 4 years is extended up to 16 years for the purpose of that income on foreign assets located outside India and which has escaped assessment is brought into the net. At the outset, I want to make it very clear that Section 149(1)(c) makes it very clear that it applies to income and not to assets. Number 2, it applies to those income which has resulted on the basis of income or on the asset located outside India. And moreover, another point, it has escaped assessment, and therefore in the reopening, this issue has been brought out. My first observation. Finance Act of 2012, which introduced from 1/7/2012 this provision of extension up to 16 years, is arbitrary. What is the basis for 16 years? This was a precursor prior to the coming of the Black Monies Act. Arbitrarily, 16 years have been extended and put. So the income tax has got power to reopen the assessments in connection with income, not assets, of arising from assets located outside India and bring to tax. Now the position is that thereafter, in 16, the Black Monies Act came into effect. So you have the Black Monies Act now. You have also got 200 section 149(1)(c). Simultaneously, under Income Tax Act, the extension is up to 16 years. Under the Black Monies Act, also you can go up to any number of years prior to 1/7/2016 by a deeming fiction. So these two acts now run in tandem and parallel with one another. In these circumstances, the question would arise which of the two acts would be preferred. If proceedings have commenced under the Income Tax Act for a period up to 16 years, that can be taken into consideration. However, simultaneously, the Black Monies Act cannot come into the play. You either go under the Income Tax Act or you invoke the Black Monies Act, but both of them cannot run. They run parallel, but you cannot invoke both of them. The third issue that I'm taking is that under the Income Tax Act, the method of accounting is normally cash or accrual basis. Cash or accrual basis is the basis for the receipt of income and the taxability thereon. In the Black Monies Act, there is a new novel concept brought about by a deeming fiction. This is brought about in section 72C, 72 being captioned as for the purposes of removal of doubt. And it says that if there is any asset which is located outside India and which is acquired or made, mark the words, acquired or made, and such assets, the question arises, the year of taxability, it would be the year when the notice is issued under section 10(1) of the Black Monies Act. So you have this new concept for assets located outside India, assets and income, which is acquired or made. So the mode of acquisition and it is made, this point arises and emanates from the time when it comes to the notice of, when a notice is issued by the assessing officer. So the position under 72C by way of a deeming fiction says that it will be presumed that the asset is acquired or made in the year in which a notice under section 10(1) is issued. This is an entirely new concept and a ball game which comes into play. And under these circumstances, the question would arise that under the Income Tax Act, the position is different, and under the Black Monies Act, the methodology is different, as we will see in the later part of the presentation. The next point is the Black Monies Act, whether it is retrospective or not. The Act comes into effect from 1/4/2016, but it is effective from 1/11/2015. So from 15 onwards, the law would apply, and it can go back up to any period and point of time. Its interplay with income tax that I want to bring to your attention is this: that taken a very difficult situation, that there is an asset which is located abroad. Say the value of the asset is £100,000. £50,000 has been declared as it comes out of the income, and so it is reflected from the sources in India. The other £50,000 is not reflected. Question is whether in such a circumstances where there is a part which is pointed out, then can in such circumstances you can tax the entire amount. The answer to that is given in section 4, subsection 3, which specifies in very clear terms that if certain portion is shown in the Income Tax Act, then such amount cannot be taxed again. In short, there is a concept of there cannot be double taxation which can arise for the same asset. So Income Tax and Black Money Act running parallel. You can't tax what is already shown in the income tax return. This is also fortified in section 5, which is the section for computation, in section 5(2), which lays down the modality and the rule of proportionality in case of immovable assets. And in such circumstances, the position would be that a proportionate, as shown in the return, and the sources of income could be allowed as a deduction. So there would be no double taxation in this particular regard. My next point is the question on penalty and prosecution. Under the Black Monies Act, absolutely parallel with the Income Tax Act, you have got the provisions of penalty and prosecution. In first stage, take section 42 of the Black Monies Act. Section 42 of the Black Monies Act says that there is a willful attempt to not file the return of income. This corresponds exactly to section 271F, where failure to file the return, and consequently it attracts the question of punishment. The punishment varies between the Income Tax Act and the Black Monies Act, but both run parallel. Second is the punishment for this is specified in section 49. So 42 is to be read with 49. And 49 is corresponding, that which says that in the case, the first is a penalty provision, the second is a prosecution provision, and that offense is punishable, similar to the Income Tax Act under section 276C. Similarly, Section 43 of the Black Monies Act, which deals with willful attempt to evade tax by filing false information or not filing correct information in the return of income. So here it is some deliberate suppression or certain wrong points which are mentioned in the return, wrong deductions claimed or not disclosing it, but the return has been filed. In 42, no return is filed. In 43, return has been filed, but the return is misleading, corresponds directly to section 271(1)(c) of the Income Tax Act or section 270A now on misreporting of income and underreporting of income. Both are punishable. This is punishable under section 276C of the Income Tax Act. The punishment varies, but otherwise it runs parallel. And finally, in 43 is to be read in conjunction with 50. And in 50, there is a punishment which is corresponding to section 277. The punishment varies, but there is prosecution. In other words, 42 read with 49. 42 is penalty, 49 is prosecution, 43 again, first is where return is not filed, return inaccurate particulars are filed in the return of income in 43, visiting with penalty and prosecution in section 50. So 42 and 49, 43 and 50 run together, penalty and prosecution. Similar mirror image is in the Income Tax Act. The only thing is that the penalty and the term for prosecution varies. Question arises whether simultaneously prosecution can be launched both under the Income Tax Act and under the Black Monies Act. The answer to this is, according to me, simultaneously you cannot be prosecuted for the same offense twice. It is not possible. Only one offense can be taken at a time, and you cannot mix the two. It is just not possible to take both of them together. The sixth point, which I like to deal on the main point in black money, is the definition which underwent a change in the Income Tax Act, Section 6, and correspondingly in Section 2(2) of the Black Monies Act on the term assessee. The term assessee has been amended to be in line with what is brought out in the Income Tax Act. And in this connection, there is absolute synchronization because the definition which was there in the Income Tax Act has been imported in the Black Monies Act, and therefore the concomitant changes are made. I would like to sum up the position on the assessee's definition and the residential status in the following 5 or 6 points. First, prior to 2015, non-residents, not ordinary residents, who were not residents in India, were not liable to be taxed on the foreign income. Number 2, now after removing the barrier and the restriction of 6(6), non-residents, not ordinary residents are also liable to be taxed. However, they would be liable to tax only up to the period from the date on which the Act came into effect, that is 1/7/2015. Third point, there is a clear-cut point that this would be on undisclosed sources of income from any asset located outside India. Number 4, that source is not satisfactorily explained by the assessee. And number 5, the memorandum explaining the provisions has made it very clear that it would pertain to income which is not chargeable to tax. Thus, now the position is that all assessees, including non-resident, resident, not ordinary resident, would also be taxed on the foreign income, with a proviso that if their stay in India exceeds 120 days. This is the summation in short of all these various provisions. I now come to certain interlinked provisions. Section 6 of the Black Monies Act, which lays down tax authorities, corresponds to section 116, which is also specified in the section itself. Number 2, take this point, that when an appeal is filed under the Income Tax Act under section 246C, one thing is clear, that when you file an appeal, the admitted tax has to be paid. Corresponding provision in the Black Monies Act is laid down in Rule 15.4, Rule 6.4. Rule 6.4, if you see, says that at the time of filing of the appeal, the assessee should have paid the tax, interest and penalty which is not disputed by him. So to the extent that the amount is not disputed under Rule 6.4, this amount is required to be paid, while under the Income Tax Act it was only the admitted tax. Number 3, at the time of filing the appeal, under section 246 and 249.3, there is discretion given to the Commissioner of Appeals if there is delay. In the Income Tax Act, there is a delay in filing the appeal. You make an application for condonation of delay, and the condonation of delay would be granted. It is a discretionary power vested with the Commissioner, and it can be any number of days and any number of years. While corresponding provision, if you see 15.4, there is a cap. Section 15.4 says that if there is a delay, then the Commissioner has got a power to condone the delay, provided there is sufficient cause. So I stop here. The word sufficient cause appears in both the Income Tax and the Black Money Act. So you have to make out a case of sufficient cause in both of them. But the Black Money Act says that the Commissioner has got a power to condone the delay, provided it is not more than, the delay is not more than and beyond 1 year. So there is a cap of 1 year so far as the delay is concerned, so far as the Black Monies Act is concerned. In the Income Tax Act, there was a much liberal and a greater approach. Then you have got section 83. Section 83 says that any information concerning return, statement, document, or any other compilation or any other important evidences furnished by the assessee in the income tax can be used for the Black Monies Act. And section 84 makes it specifically clear that certain provisions of the Income Tax Act would be imported under the Black Monies Act as if they are pari passu and forming part of the Black Monies Act, the list of the sections, major category I would divide it into. First is search and seizure. Second is liability in certain cases, including representative assessees. And number three, it would be pertaining to refunds and tax liabilities. So those sections, including attachment, are imported in these sections. There is one further important point which I wish to make vis-a-vis the definition of assessee. Question of reporting, more particularly for the chartered accountants who are filing the returns, they will have to be very careful now to find out that whether an assessee is residing in India, non-resident in particular, is residing in India for more than 120 days. That is the asset test. If he is staying in India for more than 120 days, then it is required to be reported, and the income arising outside India will also be considered. This is a question of reporting which comes into play. I now come to certain main points on the Black Monies Act. The first issue that I wish to consider is that there is a lacuna in the Act, a dichotomy and a conflict between two provisions. That the two provisions which I'm quoting to you are, in my opinion, contrary to one another. Let me first start with the question of Section 72C and, in juxtaposition, Section 211, which defines the term undisclosed foreign assets located outside India. My first point is Section 72C is a provision which is a deeming fiction. It is a deeming provision. It is also for the purposes of removal of doubt that it says that if there is any asset which is located outside India and the source of which is not explained, then even if there is a beneficial interest, that particular mode of acquisition or when the asset is made. So the word is acquisition and made is deemed to be acquired on the date on which notice under Section 10(1) is issued. Point I'm trying to bring to your notice is this, that under Section 72C, there is a deeming fiction on the date of acquisition of the asset. The date of acquisition of the asset would be taken to be the date on which the notice is issued under Section 10. So on that date, you will have to take the date on which the asset is deemed to have been acquired. Per contra, please go to Section 211. Definition of undisclosed foreign asset located outside India. It says which is held by the assessee. Which is held by the assessee in his own name or in which he has a beneficial interest, and the source of which is not able to explain satisfactorily, or the explanation given is not satisfactory to the assessing officer. So here, undisclosed foreign asset in 211 contemplates of the word held. Held as contradictory to 72C, which uses the word acquired or made. There is a big difference between acquisition, made versus held. Held means you hold the asset. Here is acquisition. If there is such a contradiction, then the two sections being difficult in interpretation, according to me, this question would arise definitely that when you come and say that this is the mode of acquisition, this is the date, at that time, the question would be whether it is held or not, and that controversy can be in a big way dealt with. Second point. See, the major point of dispute would be the year. In which year? If you take 72C, it is the year in which it comes to the notice of the, when the notice is issued by the assessing officer under section 10(1) is the date of acquisition. Please come now to section 3, proviso. 3(1) has got a proviso which says that the value of the asset shall be taken at the date when it comes to the notice of the assessing officer. So look at the contradiction again in 72C and the charging section. Section 3 is a charging section. The proviso to section 3(1) uses the word that when it comes to the notice of the assessing officer, at that point of time it is to be considered the value. The mode of acquisition is when notice is issued, the gap between the two. So the deeming fiction, according to me, for removal of doubts is creating greater doubts and making these sections not valid and unconstitutional. Let me give you another instance here. It says further that if these are the two differences, please come to section 211. Section 2, subsection 11, which says and defines assets, undisclosed assets located outside India. Are those assets which are located outside India and which is held by the assessee in his own name or in respect of which he has got a beneficial interest, etc., that I'm not coming. Now, the word used is undisclosed asset which is held either in his own name or in which he has a financial interest or a beneficial interest. Take an example. Asset was acquired abroad, not declared and disclosed in 2003. 2004, the asset was sold. 2005, the proceeds were totally spent. 2006, nothing exists. In such circumstances, if notice is issued under the Black Monies Act for undisclosed foreign asset located outside India, can it be said that the asset number 1 is held by the assessee? Because here the word is held by the assessee. Number 2, it is further qualified in his name or in which he has a beneficial interest. If the asset itself is non-existent, it is non-extincta, then in the first place it can't fit. within the parameters of the definition under section 211. So in all those cases where asset has been disposed of but the information is available and there doesn't exist anything, on a literal interpretation of the provisions of section 211, it can safely be said that viewed from any angle, it is not held. Number two, viewed from any angle, you cannot say it is in his name. That says that it continues. All this is further qualified by one word, located outside India. So the word held is to be read in conjunction with the word located. So it must be located. It must be held and located. If the asset doesn't exist, there is a question of its location. There must be some particular place where it is located. There is no, it was in the past tense. That doesn't apply in the present circumstances. This is a very big difference, making a constitutional point a matter of challenge. And here I would say and describe this and the next provision that I'm dealing as legislative misfire. This is pure instance of legislative misfire. Take the next instance. Please see section 53.1 and 53.2. 53.1 deals with willful attempt to evade tax, interest, penalty, and then it visits with the fine and punishment. 51.2 51.1 and 51.2 deals with the question of willful attempt to evade tax, interest, penalty, and the payment thereof. So, in short, what is the difference between 51.1 and 51.2? 51.1 talks about willful attempt to evade tax, interest, penalty, and 51.2 in the same section talks willful evasion for making payment of such tax, interest, penalty, and the consequent punishment. I want to start this with a proposition that first, section 51.1, willful attempt to evade tax, interest, penalty cannot apply in the black money's case. Why? First proposition I'm canvassing to you is that there is no concept of self-assessment under the Black Monies Act. Number two, whatever is declared in the income tax return would be taxed. What is not taxed, what is not declared, that would be taxed after the return is filed. After the assessment, there is determination of the payment. There cannot be when there is no self-assessment at all. The issue of willful attempt to evade tax, that section is rendered otis and whichever way is redundant. Because under 10.1 there is a mechanism and a machinery for making the payment of tax. The payment of tax would come only after the determination of the totality of the income and the assets, etc. is taken and the assessment is made. After the assessment, the question of payment of tax comes. To this extent, therefore, Section 51(1) is totally redundant and therefore, in my opinion, deserves to be struck. Constitutionally, as well as, in my opinion, you can have only in the Black Monies Act willful attempt on the question of evading payment of tax. But since you have just borrowed the entire language and everything from the Income Tax Act, in my opinion, the provisions of 51(1) and the harsher punishment mentioned there, set to 7 years, would not survive and is not tenable in law. Take the second point. The second point which I'm bringing to your attention is Section 51(3), the next section, subsection. 51(3) says that willful attempt to evade tax interest penalty is described. They are laid down certain circumstances as to how there are 4 circumstances. Please compare these 4 circumstances. First circumstance is 1, 2, 3, 4. The first one is that person who has in his possession certain books of accounts in which there is false entry. Second one is the person who deliberately makes false entry. Third is who omits or causes to omit false entry. And the fourth is any other circumstances which would have the effect of evading the tax interest penalty. This is carbon copy taken from explanation to Section 76C of the Income Tax Act. So Income Tax Act, this is explanation to Section 76C with these 4 conditions, same language, word to word, incorporated here under 51, 1 and 2. But these 2 things are the same, assuming on the payment part, if there is a delay or default and there is punishment under the Black Monies Act under 51(2), because of the circumstances which are explained in 51(3), then in my opinion, the department cannot proceed under 76C. You cannot, when the language is same, when the entire position is identical, prosecute a person both under the Income Tax Act and under the Black Monies Act on an identical issue. This will amount to the concept of double jeopardy. This is a question of double jeopardy when, for the same offense, identical point, a person is punished twice, which is also against the Constitution of India. So therefore, in short, these are the lacunas and misfire. 211 versus 76C, Provisio 231 and 72C, Section 51(1) is totally academic and does not apply, and 51(3), which corresponds directly to the explanation in 76C, being in pari materia same, you cannot be prosecuted under 276C and again under 51. That is not possible, and you cannot be punished for the same offense twice. These were my certain legislative misfires and important issues on the Black Monies Act. Let me deal with a few case laws now. The first case law which I would like to deal is the case of Brahmadat, Delhi High Court, 100taxman.com, page 324, Delhi High Court. Let me explain to you the facts of the case. Brahmadat, Indian, went abroad, settled in the United Emirates. From 1984 to 2004, he was staying in the Emirates. He earned income and he created various trusts. There is no controversy at all on those trusts or the income. He came back to India, then stayed in India, complied with the tax laws. He filed the return first as a non-resident, then resident, then not ordinary resident, and then as a resident. There was a search and seizure operation at his premises in 2011. And in 2011, when the search and seizure operation took place, certain questions were asked, and based on certain information, they came to the conclusion that income has escaped assessment and issued a notice of reopening. The reopening notice was dated 24/4/2014. It pertained to the assessment year 1998 and thereafter. This notice under 148 was challenged before the Delhi High Court. The Delhi High Court very correctly laid down the proposition that when a time limit is prescribed and a limitation is placed, there is a bar of limitation of time, that cannot act retrospectively unless it is specifically stated. It cannot act. A bar on limitation cannot go retrospectively to earlier years. In Brahmadat's case was, what has happened is, notice of reopening was issued on 24/3/2015. They said the act applies retrospectively. In this case, please note, the period of 6 years were applicable in Brahmadat's case. The 6 years period had already expired in the year 2005. Therefore, the Delhi High Court struck down the notice under 148 on the ground 2 points. Number one, that the period had already expired of the 6 years. And number two, when the statute has given a bar on the limitation, that cannot act retrospectively. I come to the second case. Huge facts. I've narrowed it down for you. It is the case of NDTV, decision of the Supreme Court, which is reported in 2020 116 taxman.com, page 151, Supreme Court. Let me summarize it and explain to you the case in a very simplified manner because there are a lot of points. Let me start it in this way. We are concerned with assessment year 2008-9. In 2008-9 assessment year, NDTV's subsidiary, it is a step-in subsidiary located in the United Kingdoms, issued bonds. The bonds were issued with the condition that these bonds were for a period of 5 years. And on the expiry of the 5 years, the bonds would be redeemed at a premium. However, what happened was the bonds were redeemed, but not on 5 years tenure, but much earlier to that, and that too at a discount. So the original issue was that after 5 years, you'll get a premium. What was done was less than 5 years and at a discount. This created a little suspicion, and this was also one of the grounds in issuing a 148 notice. Assessment year 8-9-10, the next year, the matter on a similar identical issue was before the DRP. The DRP on a similar matter and similar circumstances was seized of the matter, where also bonds were issued. the DRP observed that number one, the UK step-in subsidiary located in UK technically has no business at all. Number two, it has no financial status or stability or the means except for the credibility of NDTV. Next, that it was not even able to pay the rent, leave apart the running of the business. It was just like, in short, not mentioned, but I'm saying for you, like a shell company who had no business, but was just there to route the round tripping of funds. But the DRP observed that this money which was round tripped was the money of NDTV only. Based on that information, notice under 148 was issued to NDTV. This was the background for the issuance of 148 notice. Matter was taken before the Delhi High Court. The Delhi High Court upheld the notice issued by the assessing officer. The matter was carried to the Supreme Court. The Supreme Court in NDTV's judgment first stated that the step-in subsidiary, according to us, has no existence at all. Number two, they agreed with the findings of the AO that there is a dubious transaction, that this entire ball game in which the funds were rotated, they even went to the extent of saying, appears to be funds of high-ranking people whose monies were rotated. Number three, they said that the view taken by the assessing officer that the transaction is dubious, that the transaction is fictitious, appears to be correct under the facts and circumstances. However, this case, the notice was issued beyond 4 years and within 6 years. So the jurisdictional condition is required to be fulfilled, and the jurisdictional condition requires that all material facts have been placed before the assessing officer and that the assessee has made fully and truly disclosure of all material facts. The Supreme Court observed that there was an assessment under 143.3. Under the 143.3 assessment, number one, all these facts were disclosed. Number two, there was a guarantee given which was also brought to the attention of the assessing officer. Number three, not only that, the bond issue was also disclosed. Number four, there was even a transfer pricing adjustment, a TP adjustment which had taken place in this regard. Number five, there was an issue of commission, and the commission was also added. On these bases, the Supreme Court held that all the primary and the basic materials required were placed before the assessing officer at the time of the assessment under 143.3. That, having placed all these materials before the assessing officer, there was no failure on the part of the assessee to fully and truly disclose all material facts which were required for the purposes of assessment. All the material facts having been there, the Supreme Court on that basis struck down the notice under 148. However, the department argued at this stage that, see, 6 years, but now under section 149.3c, the period of limitation is extended, 149.1c, the period of limitation is extended to 16 years. So therefore, we are still within that period. The Supreme Court in this regard said and made an observation that the reference to 16 years does not appear either in the reasons to believe or in any documents or in any stand taken by the department, nor in the notice under 148. Based on this, the Supreme Court said that we cannot entertain the plea of 16 years here. However, liberty has been granted to the department to take suitable action under 16 years or under whichever other law, which means that either under the Black Monies Act if there is a trade, or if you can go under 16 years, whichever course is open, you can take it and go ahead on that. That is the decision of NTTV. I come to the third decision which I wish to deal, and that is the decision of Srivardhan Mota versus Union of India. This is reported in 307 CTR, page 396, Calcutta High Court. In Mota's case, what happened was, there was a person who had 4 bank foreign accounts. Please note these 4 foreign bank accounts which came were inherited by him from his mother. He had not disclosed it at all in the return of income, since he said it is a matter of inheritance which had come to him. There was a search and seizure action. Thereafter, proceedings under 143A notices, etc. were issued. Mota went before the Settlement Commission when the proceedings were pending before and thereafter completed. The Settlement Commission, unfortunately, did not accept the petition on the ground that full facts were not disclosed or given. The Settlement Commission therefore rejected his petition. When the matter was challenged in the court, it was argued that I was prevented from approaching the court and to take suitable action because of the provisions of section 71. See, in Mota's case, the section applied was 51 and 55. 51 deals with willful attempt to evade tax and the payment thereof. Number 2, please note, 55 is sanction and 71 is a peculiar section which says that if the clause relevant for our discussion in 71 is 71(1)(d), D2 and 3, which says that if any matter where a notice is issued under 153A or 153A proceedings are pending, then the person need not make and go to the time limit could be excluded. Under these circumstances, Mota made a plea that he cannot be prosecuted. The Delhi High Court, in this case, came to the conclusion that no, even failure to file and disclose return and give full particulars under 153A would attract the penalty and prosecution under the Black Monies Act. See, the point which I'm trying to make is that even if there is a failure or false verification or wrong declaration, or if the department feels that even in search and seizure operation returns, there is a mistake or there is willful attempt to evade tax, then automatically the provisions of penalty and prosecution under 51 would apply. However, here one other important point which weighed on the mind of the judges in deciding Mota's case was that the court observed very clearly that his Settlement Commission petition was rejected. The Settlement Commission very clearly pointed out that full and true disclosure was not made, and in the light of that, the petition for quashing 51 notice was rejected. I come to one more case, and this is the case of the Supreme Court in Gautam Khaitan, reported in 420 ITR, page 140, Supreme Court. I'm just giving you the important substance of what the Supreme Court said. It's on section 3, the chargeability. The question arose of retrospectivity of the Black Monies Act. The court laid down the ratio very clearly, and I would sum up the entire judgment in this way. The Supreme Court held that section 86, which gives powers to the government to frame rules and to remove difficulties, 84 and 83 and 85 and 86, to remove difficulties, section 83 does not in any way bring about retrospectivity. The Benami Act was passed by the Parliament on 25th May 2015. It received legislative precedence approval on 29/5/2015. By section 1, subsection 3, the Act came into force from 1/4/2016, and by a notification, the Act came into operation from 1/7/2015. So the court said that no, you don't have to look into all these points for the question of retrospectivity. The acid test which the Supreme Court laid down is this: that if a person is charged with any offense under the Black Monies Act, and if he has not taken advantage of the declaration which is contemplated in section 59 and has not paid the penalty, tax, and interest thereon, then he would be exposing himself to the Black Monies Act, which takes effect from 1/7/2015. This is in short the approach on the Black Monies Act. In context with the resident, I want to conclude by this, just 4 points. Number 1, assets and income located in India is not covered. So income earned in India, assets located in India is not taxed. Number 2, asset located outside India, income earned outside India would be taxed in India under the Black Monies Act. Number 3, income earned outside India but brought into India or an asset created thereafter in India would be taxed in India. Number 4, the criteria is whether the asset which is in existence abroad or the income thereof is undisclosed, no explanation is given as to the source of it, then the taxability would arise under the Black Monies Act. And I would like you to take into consideration the lacuna, the constitutional validity, and the points concerning 72 vis-a-vis section 3, section 211, and the non-redundant section, which is a punishment section, section 71(1), and that doctrine of double jeopardy, where a person cannot be prosecuted simultaneously under the 2 acts. This brings me now to the second act, the Benami Transactions Act. In the Benami Transactions Act, first let me give you some few highlights. The first point is, under the Benamis Act, Old Act of 1988, Section 5.1 dealt with the concept of acquisition. So under the Benamis Act, there was acquisition of the asset. Under the new law, the concept has totally changed. The concept now, which comes into effect in the Benami Act, is confiscation. So you had in the old Act, Section 5.1, which dealt with acquisition. You have now in the new Act, same Section 5.1, instead of acquisition, you have got a new concept, confiscation. Let me deal with it. Under the old Act of 1988, dealing with acquisition, if you notice, there was no machinery provision. There were no rules. There were no modalities and guidelines laid down to the government officers or other people as to how to execute the question of acquisition. Governmental agencies and authorities who were entrusted and empowered with the question of acquisition of the assets had no way to acquire the assets because there was no machinery section. There was no procedural section. There was no machinery to implement the issue of acquisition. If you see, all litigations under the old law, all these litigations technically are litigations between two private parties. They are not with the government. Note that. One observation, that these litigations are between private parties going right up to the Supreme Court. There was no acquisition which took place. From 1988 to 2016, almost 30 years, there were no acquisitions at all. The old Act had become literally outdated, had no methodology of implementation, no machinery and mechanism on the issue of acquisition, and therefore in the new Act, instead of acquisition, they brought in the concept of confiscation. So here the confiscation now arises. So what happens? That if there is a property which is of the Benami and there are outstandings, then the property can be confiscated by the government, and then the government has got full power over the confiscated property. Section 24(3) deals with the fact that the central government has got the full power with the board to confiscate the property and no compensation would be granted. One issue. Property, also subject matter of income tax, Benami transaction, property confiscated by the government, but there are outstanding dues. So there are outstanding income tax dues. Can the assessee tell the government that, see, it is of the same property, there are outstanding dues of the property on income tax front, please appropriate my outstanding dues of tax against the confiscated property? Can such a plea be taken? The answer is apparently no. Once the property is confiscated, there is no compensation at all, and the question of any kind of adjustment of outstanding dues does not arise at all. I deal with the second issue. The second issue that I'm dealing with you is now on retrospective amendments. I'm not on retrospective law. I'm on the retrospective amendments. Certain provisions come immediately, certain provisions come later. I'm on the retrospective amendments. In looking into the retrospective amendments, there are two types of retrospective amendments: substantive amendments and procedural amendments. It is strike law that substantive amendments, for example, in section 3, 5, etc., these affect substantive right. In fact, the right of confiscation is a substantive right. There can be instances that there is a machinery provision also for appeals, etc., against confiscation. But since there is confiscation, there are a number of cases in the Supreme Court on confiscation being challenged, because confiscation of a property is violation of fundamental right. And a fundamental right also can be challenged under these circumstances. So the question is that substantive amendments are all prospective. Now I come to the procedural amendments. Here also it is settled law that if there is a procedural amendment, the amendments are all retrospective because they deal with the procedure. Say concerning appeals, concerning procedures, concerning how attachments, etc. to be done. However, my answer to that is that if you look at the framework of the Benami law in the light of section 5 on confiscation, I am of the considered opinion that all these procedures ultimately lead, what is the target? They ultimately lead the assessments, etc., to provisional attachment, thereafter to attachment, thereafter to confiscation. So if there is per force ultimate objective of confiscation, the ultimate target being that, then all this affects substantive rights, and therefore all procedural amendments also are in a way substantive, and the Act therefore in all the provisions would apply only prospectively. This is a thought which you can think it over. The third issue is, I had already referred to that issue earlier in the Black Monies Act, but I'm dealing now in a little greater details, that since Benami Act and the Income Tax Act also run together in parallel, and together they converge, are intermingled, interlinked. Can a person be punished for an offense both under the Benami Act and under the Income Tax Act? The answer to this is, I'm looking at it and straight away saying that for the same offense, a person cannot be prosecuted under two different statutes. Answer to that is Article 20 of the Constitution. Article 21, 20 into bracket 1, very clearly states that no person shall be convicted of any offense which is not cognizable at the time when the offense is so charged. So the first argument in the first point is, you have to look at it whether in the first circumstances, at the time when the offense is committed, whether the act itself was in existence. If the act is not in existence, then looking into Article 20 of the Constitution, you cannot be prosecuted. Look at now Article 20 which says that no person shall be prosecuted or punished for the same offense twice. He cannot be charged with the same offense once again. The Constitution makes it very clear that prosecution and punishment cannot be for the same offense. A person cannot be charged once again, that is twice. In my opinion, therefore, both under the Black Monies Act and under the Benami Act, the position is no person can be simultaneously charged for the same offense under the two acts. If there is such a kind of prosecution, the same could be challenged in the court to quash any one of the proceedings. I come to the fourth point in the Benami Transaction Act, which deals with burden of proof. For the first time in the new Act of 2016, the concept of burden of proof has come into the picture. I am proceeding this way that if you look at the laws, case laws earlier, courts have held under the old law that it is the duty of the person who alleges that this is a Benami transaction, the owner or the beneficial owner or the apparent owner has to prove the same. Originally, the burden in certain cases by way of a presumption was on the prosecution. Now, the entire mechanism has changed. The entire burden of proof is on the assessee by way of a new mechanism akin to Section 147 on reopening under the Income Tax Act. What is the position and the mechanics of burden of proof? Section 24(1) says that if on the basis, number one, of the materials available, number two, the assessing officer forms a reasonable belief, number three, he records the belief, number four, he issues a show cause notice to the person, then the other person has got the responsibility to explain and discharge the burden of proof. In short, what I am canvassing before you is this, that now with the mechanism of burden of proof coming into the picture, the onus has shifted directly upon the assessing. The assessing officer can just issue a show cause notice, say that this is a Benami transaction, therefore, please explain. If not, I will attach the property. So the entire burden has shifted on the assessee. The assessee will have to establish it in very clear terms. Please note, with the burden of proof, I am bringing in a concept. See, under the Income Tax Act on burden of proof and that line of arguments, we have this concept of preponderance of probability. Leading judgment in this connection is the decision of Sumati Dayal, 214 ITR 801 Supreme Court, where the court went into the probability, surrounding circumstances, etc. In my opinion now, this concept of preponderance of probability cannot be imported in the Benami Transaction Act. The definition of Section 2(9) of Benami transaction makes it very, very clear. What is a Benami property is also made clear in 2(8). You will come within the parameters of a Benami transaction if you fall only within A, B, C, D. Illustrations and points laid down in Section 2(9). If not, you cannot go on the basis of surmise, conjecture, preponderance of probability. that ratios laid down by the Supreme Court would not apply positively on a burden of proof in this instance. So I'm trying to bring out to you now 3 points. Take, for example, like a chart. First, section 2(9), Benami transaction. In a Benami transaction, ABCD, whether fictitious person, etc., ownership, all those points, your nature, source has to be explained. Number 2, section 24(1), where burden of proof, issuance of so-cause notice, reason to believe, then the consequence of this is what? The consequence of this is attachment by the initiating officer. The initiating officer has got a power of provisional attachment. He will then send it over to the commissioner, to the adjudicating authority. Under section 26(1), the adjudicating authority will look into that and then issue final orders of attachment. So there is a mechanism given. And section 2(8), which deals with Benami property, property of any kind, which is a matter of Benami transaction, and the proceeds of sale thereof. So all this on the burden of proof, now there being a mechanism which requires to be followed. This may culminate into confiscation under section attachment, final, and then confiscation under section 27(1). On the point of interlink between Benami and income tax, the section which comes to anyone's mind is section 68, unexplained cash credits. And the classic illustration in section 68, if you ask me, would be on unsecured loan. Let us split this in a very clear manner. There is an unsecured loan received by a company. The company has received unsecured loan and from the unsecured loan purchased the property, asked for the sources of funds to prove the genuineness of the transaction. The genuineness of the transaction is in doubt. Therefore, since identity, genuineness, creditworthiness, nature, source not explained, it is added as the income of the company. So you have got an instance under section 68 where the source is not explained, it's fictitious party, bogus party. Therefore, the addition is made under section 68 of the unsecured loan. Now the initiating officer comes to know that this is a fictitious transaction so far as the property is concerned. Therefore, he invokes the Benami law. A Benami law is invoked, and let us go one step further, that in this instance, the addition of that loan, the loan is fictitious and the property is attached. So there is two parallel points, one under 68 where addition is already made, and a Benami transaction issue arising on the unsecured loan, which is already a subject matter of section 68. What would be the difference? In my opinion, I start first with a general proposition that in all cases where section 68 applies, the provisions of Benami transaction can never apply. Take our illustration concerning the loans. First argument could be that, see, this is an unsecured loan. A loan is a liability. A liability cannot be taken under the Benami's Act, it is not contemplated at all. Neither does it fall within the framework of the definition in 2(9). Second argument. This is an unsecured loan which you say is fictitious. Therefore, it is added as my income. Once it is added in my income, then the department has accepted the position that it is my income, my property. The same department cannot take a contrary view in the Benami Act, under the Benami Act, by saying that no, Income Tax Act, we have taken a different view. Now, under the Benami Act, we are taking a different view. Third, this cannot be sustained more particularly when the administration of the Benami and the Income Tax Act is done by the same authorities. They are the same authorities who are administering the act. Therefore, there cannot be an inconsistent stand between the Benami Act and the Income Tax Act. You have to have both them in the same line and flowing together. This is on section 68, can never apply. I take the fifth issue, and that is on share capital and share application money. Number of cases on share application and share capital, that share application money is given to the company. It is found that the person given is fictitious, bogus, binamidar, etc. Based on that and based on inquiry from the government and the directorate, what is done is that there is addition under section, say, 69, unexplained money. So when there is an addition on the ground that the share capital or the share application money is bogus, can Benami again be invoked? The answer to this is no. The position is very clear. As I laid down the first general proposition, that once if you start with a point of making an addition under the Income Tax Act, you can't again invoke the Benami Act. I go one step further. I said this was share application, share capital. So shares are issued. Let us go in this way, shares are issued. And Benami Act is invoked. So the first logical consequences would be that the shares are attached. Take extreme example that the underlying asset of the company and the only asset is the property. So shares are attached. Then they are saying, let us attach the property. Can this be done? Answer, no. First of all, on the basic proposition, but here I am tempted to quote the old case law of Bacha F. Gazdar versus Commissioner of Income Tax, reported in 27 ITR page 1, where the proposition laid down by the Supreme Court is that a shareholder has got a right to the income of the company, but not to the property of the company. So what you can do is maximum you can attach the shares, if at all the Benami transaction is taken. First of all, I said both cannot be invoked. But based on this judgment of the Supreme Court, beyond the shares, even if it is an underlying asset, you cannot under any circumstances go ahead and do this. Section 69, now I come to 69A. Say entries in books of accounts, and here I want to conclude by a very simple point by saying that number one, if a person has in his books of accounts made an entry but not disclosed to whom it belonged, then section 69A could be invoked. But if a person makes a particular entry in the name of some other person, some other fictitious person, or the person who is not the main person, then in such cases, the Benami law can be invoked. Certain other provisions which require consideration would be, first, let me take section 53 and section 62. And starting with one simple point, section 62, 53 is willful attempt to evade tax. Section 62 is offenses and punishment. And in that section, I am emphasizing on the explanation to section 62. Explanation to section 62 defines first the term company to include a firm and an AOP. So even when a reference is made to the company, it includes a partnership firm. And number two, the second definition of director, the director's definition includes a partner or a member of the AOP or a BOI. So with this particular background in mind, question is, for a partner of a firm or director of a company, would the liability under Benami arise? In a partnership firm, the partnership in law is only a compendium by name. No separate legal existence, though under the Income Tax Act there is a separate legal existence. So far as the company is concerned, it's a separate jurisdictional entity. Yet the directors would be liable only if you can prove that there is some nexus in willfully evading the tax. This ratio was decided in a slightly different context by the Bombay High Court, that the liability can arise for the partner, the liability can arise for the firm if there is some attribution, if you can say that he had participated in it. If not, then it cannot be done. This is reported in ANZ Grinley's Bank case versus Union of India, reported in 1999 Criminal Law Journal, page 2940, 2940, 199 Criminal Law Journal, Bombay High Court. Second issue which I would like to consider is, what is the distinction between sham transaction and Benami transaction? Because these are very interplay. Sometimes in the Income Tax Act, all the time you say that this transaction is a sham. So can a Benami transaction and sham transaction be treated as equivalent? First point, a Benami transaction according to section 2(9) means a transaction or an arrangement. So there is an arrangement which is done. Please note, in a Benami transaction, there are two stages of the transaction. In a sham transaction, there is no stages of transaction. Take for example, in a Benami transaction, the name is substituted by some dubious name, fictitious name. But in a sham transaction, the main motive is what? Bogus purchases, fictitious sales, gross profit reduced by some means, bringing in bogus expenditure, reducing net profits. These are all sham transactions, bogus vouchers, bogus invoices being introduced. These are sham. While in Benami, there are two stages of transactions, and the transaction has taken place. In a sham transaction, the transaction has not taken place. bogus issue, bogus vouchers, bogus invoices, wrong indenting. So look at the difference between a sham and a Benami transaction. The best way to illustrate between a sham and a Benami transaction was laid down earlier by the Supreme Court itself in the decision of Meenakshi Mills versus CIT, reported in 31 ITR, page 28. 31 ITR, page 28, Supreme Court, Meenakshi Mills, page 36, Supreme Court gave the following illustration. Supreme Court said that there are layers of transactions, and a transaction in fact has taken place in a Benami transaction. It says that if X sells the property to A, but A says that instead of A, put the name of B, then B is the Benamidar of A. The transaction has taken place, but the transaction is one in which the real owner A is not reflected, but it is B who is the Benamidar of A. The Supreme Court continues further and says, but say, take a further instance of a sham transaction connected with the Benami transaction. And that is, that if X sells the property to A, but A says that though the property is sold to me, do not put my name in the books. Therefore, here the transaction has taken place, consideration has passed, but the real owner is not reflected at all. This could be an illustration of a sham transaction. And this illustration, the Supreme Court concludes with the following point, that in such instances, the test to be applied is not that the consideration is paid, but the question is to whether the consideration has passed at all. To whom it is paid is not material, but the material point to be examined is whether in such a circumstances the consideration has passed at all. This is Meenakshi Mills' illustration. I come to the next point, whether, as we were dealing with the Black Monies Act, whether property located outside India can be subject matter of a Benami transaction. In this connection, there is clarification issued on 2/8/2016. Clarification of 2/8/2016 makes it clear that since the Black Monies Act is a special act which is enacted, in this connection, the Black Monies Act would apply to property situated outside India, and the Benami law will not apply to properties located outside India. And one last point which I want to take into consideration in the Benami law is Section 60. Section 60 of the Benami Act says that the Benami law is in addition to and not in derogation of any other provisions. So this act is in addition to and not in any derogation. This is to be read with Section 67. Section 67 says that this act has an overriding effect. So the question now is that you have an overriding effect under 67, that this act is in addition and override is in 67. So question is, which law would prevail if there is a conflict between the two laws? The general principle, this would apply even to black money and to money laundering and the Income Tax Act. The general principle, the first proposition I'm laying down is that Income Tax Act is the primary law. Benami is supplementary law. It runs supplement to it. And secondly, that if there is a conflict, if there is a dispute between the two laws, which law would prevail? The answer to that is given by the Supreme Court in an old judgment, first Soliditaire versus Fair Growth, reported in AIR 2001, Supreme Court, page 958. In Soliditaire case, the Supreme Court laid down the proposition that if conflict appears between the two acts, which are both special acts, then the latter act will prevail. So the one which is later in the point of time would prevail. This was the law laid down in AIR 2001, Supreme Court, page 958. However, subsequently, there was another judgment. In the subsequent judgment, the same controversy came, and the Supreme Court analyzed and said that we should not be bogged down only with the concept of which is the later law. What is required to be seen, if there are two special acts, if both these acts and the sections contain a non-obstanta clause, then in that case, the real criteria to be taken into consideration is that you have to go into the legislative intent, the meaning which comes more near to the legislative intent, and one has to then read the statement and the objects and the purpose of introducing the statute. That should be taken into consideration, and not merely the test that which statute is the latest one. This ratio is laid down in the case of Bank of India versus Khetan Parekh, 2008, 8 SCC, page 148, Supreme Court. This completes certain points on the Benami transaction. Now let me come to the case laws on the Benami transaction, and let me explain to you it in my way. The first case that I'm dealing with is the case of Lalita versus R. Shankaranarayan Rao, reported in 263 Taxman, page 105. In this case, the Supreme Court laid down 6 tests. The Supreme Court stated that in order to examine whether a transaction is a Benami transaction, regard should be made to the following 6 tests. You have to look to the motive, the sources from which the funds came, the possession of the property. Number 4, the relationship between the parties, the custody, number 5, of the documents after sale, and number 6, the conduct of the parties after sale. So these are the 6 criteria laid down by the Supreme Court in Lilavati's case, which is under the old law of 1988. In Lilavati's case, the point was that financial assistance was given by the plaintiff for the property, whereas the intention of the father was that the property was not to be treated as property of the family, but it was for a specific people, for the daughter and for the son. The mere fact that financial assistance is given cannot be a ground to invoke the question of whether the transaction is Benami, and the Supreme Court said that in this case, mere financial assistance given by the plaintiff would not entitle the plaintiff to 1/4 of the share in the property of the family as alleged. The second case, which I'm dealing is the case of Virendra Soni versus Dcit, and this is reported in 414 ITR, page 722, Gujarat High Court. In this case, some high denomination notes were brought into the picture, and these notes were then transferred and made to show that these were for the purchase of some gold bars. The entire transaction was not genuine, it was in fictitious names, and therefore the Benami transaction issue arose. In this case, a very interesting point arose. A summons was issued to other person also, one Yogesh. Details were collected by the officer, and in Virendra Soni's case, the assessing officer recorded reasons based on material and issued show cause notice. Reply to that was filed with some evidences. The officer rejected that as not substantial evidence being given, and thereafter provisionally, and thereafter rejected the claim of the assessee. The assessee filed a writ petition in the Gujarat High Court saying that I filed a reply and an objection to the reasons to believe, and therefore is required under section 147 in the concept in Drive Shah's case of the Supreme Court. The officer is bound to dispose of the objections first before passing the order of attachment or passing the final order. The Gujarat High Court in this case said that the two provisions, the provisions laid in the Benami law under section 24, 1 and 2, and section 147 and 148 both operate in two different directions. Both operate in two different fields. You cannot confuse them. They are not in pari materia. The Supreme Court said that section 147, 148 deals with assessments and reassessments. That the provisions concerning 24, 1 and 2 deals with assessments and deals with the assessments in case of Benami and in the question of attachment. Both operate in different fields, both are not in pari materia as contemplated by the assessee. And therefore, in Virendra Soni's case, 414 ITR 722, the Gujarat High Court laid down the proposition that you cannot compare, you cannot make that the reason to believe being there, the modalities laid down under the Income Tax Act should be followed. That brings me to the third case law. The third case law is pointed out for the purpose.
Sorry to interrupt you.
Yeah.
It's already 12:15, and how much time more you will take, sir?
What's the time, Babu?
1 o'clock.
Oh, I would take another. Okay, I'll try to curb it by another 20, 25 minutes.
Okay,
would that be okay? 20 minutes would be okay? Because I have to deal with money laundering.
Yes.
Is it okay?
Yes, sir. You can continue.
Yeah, I'll continue. Sorry. I'm sorry for the time, but got involved in it. The third case law is between the old act and the new act. And in the old act, in the new act, the law under the old act stated that the onus is on the prosecution. While under the new act, the burden is entirely on the assessee or on the person who claims that it is a Benami transaction. under these circumstances, the comparison between the old law and the new law is that under the new Benami Act, the burden of proof now shifts entirely on the person who claims to be the owner or the Benamidar. If it is done, then what happens? Then the court says, then the tribunal says, this is a tribunal judgment, that both would converge. Both would converge, and what would happen is that the general law and other provisions under the Evidence Act, the Civil Procedure Code, and other laws would come into effect. This is the judgment of initiating officer versus Manpreet Estates LLP. I come to the fourth decision on Benami. It is of ISKCON Ceramics. ISKCON Ceramics was a company manufacturing ceramics, tiles, etc., sanitary work. It entered into a contract with one company, ACML, for 75 lakhs for supply of tiles. The 75 lakhs was paid not by ACML, but by another company, DMCL, which routed 75 lakhs. ISKCON came to know that this amount which was given is that of ACML, who is in the business of money laundering, Benami transactions. Therefore, it returned the money and cancelled the contract. This is a case where I'm trying to deal with return of cancellation of contract and return of money on a contract. In such case, the initiating officer said that no, this is only a Benami transaction and a route that these ISKCON Ceramics tried to route the money through another company and brought the money back in its own account. The court, the tribunal, this is a tribunal decision, ISKCON Ceramics versus initiating officer. This is reported in 265 Taxman, page 364, Appellate Tribunal's judgment, where tribunal said that you have not brought sufficient materials, there is no live link, there is no nexus which is established. So here, even in Benami, what I'm trying to bring, like in income tax, the link, the nexus, the source, all this also requires to be established, as pointed out in ISKCON's case. The next judgment that I'm dealing is a judgment which dealt both with the old law and with the new law. Mangalathai Amal versus Rajeshwari. And this is reported in 267 Taxman, page 506, Supreme Court. In Mangalathai Amal's case, there was a case of part payment of property, stamp duty paid by another person, property purchase for the wife and for the benefit of the wife and minor children. In the old days, it was presumed that it was for the benefit of wife under section 3(1) of the old act, which presumption has been given a go by and omitted under the new act. The court held, this is a Supreme Court judgment, the Supreme Court held in Mangalathai Amal's case that the law will not operate retrospectively. This is the main point, and it again followed the earlier decision of Lilavati and said that intention, motive have to be considered. What was the original intention of the person who made? So this is a case of part payment and also of another person making the stamp duty. Just one thought which I'm going to give it to you. See, originally the courts went, I told you the litigations, if you see, all the old litigations are between private parties. Question is of motive test laid down by the Supreme Court. Intention of the parties were looked into. Now with the burden of proof and section 24 coming into play, issue is whether intention has still to be taken into consideration. It's a debatable point, but in my opinion, intention will still prevail, and that is for sure. I come to the last case where I'll just give the propositions. And this case is Nick Harilal Jain versus Union of India, reported in 107taxman.com, page 272, Rajasthan High Court. Nick Harilal Jain's case lays down three propositions. Number one, it lays down that the law which is normally enacted is prospective. If a law is enacted prospectively, you cannot give retrospective effect. Number two, I've selected this case for a very particular purpose, and that is that here even a tax planning device, the doctrine of McDowell was used for the purpose that there is a tax planning. The court held, Rajasthan High Court held, that the device of tax planning and McDowell's case cannot apply retrospectively. And the third proposition which I'm referring to this case is for the point that the court held that under Article 226 and 227 of the Constitution, it is absolutely imperative that the court should exercise its inherent jurisdiction so that the litigant and the person is not put to unnecessary hardship, delay, and unnecessary litigation. These are the three propositions which I have quoted for the Rajasthan High Court. I now come to the Prevention of Money Laundering Act. In the Prevention of Money Laundering Act, I will just deal with in a short way. First, what are the steps? Number one, steps are, this is crime money. Crime money, you want to make it legitimate, bring it into the economy and into the system. Number three, you want to make the tainted money as untainted money. These are proceeds of crime. Proceeds of crime related to scheduled offenses. And finally, there is attachment and confiscation. These are the steps. See, Money Laundering Act again has come out, according to me, similar issues as in the Income Tax Act attempt is made. Just 2-3 illustrations. Number one, in the Income Tax Act, you have got section 56(5) on gifts, where foreign gifts received abroad and all bogus gifts, that can be looked into. Why? For the purposes of whether it pertains to crime money. Number two, section 56(2), where the question arises on justification of share premium, that why have you charged such huge share premium? Number three, section 58, where company has to justify its own financial transactions and soundness in certain ways. So therefore, all these provisions are there. I want to point out very emphatically that information in the possession of the income tax officer is handed over to the enforcement directorate to look into only from the angle whether these are proceeds of crime. So, proceeds of crime, only if they are there, then the Money Laundering Act would apply. Now, you have a system. You have got your PAN. Your PAN is linked with Aadhaar. The Aadhaar is now linked directly with your GST registration. Then there is also information with the government and the income tax department on your banking transactions. There is also the direct connection on the stock market transactions entered into. So all this is within the purview. This can be looked into. But what can come within the purview of Money Laundering Act is only that proceeds of crime which are connected with the scheduled offenses. I have used one term which I have coined it. See, there are disguised money laundering. Disguised money laundering is what? Some transactions which are for money laundering, but say penny stocks, bogus purchases, or some fictitious entries which are made. These are all with a dubious intention to evade tax. So there is evasion of tax, but the ultimate money is not aim, and the source for the money is not to pay the tax, to evade tax, but there's no connection with crime money. If there is evasion of tax, but it is not the offshoot of a crime or proceeds of crime, the Money Laundering Act would not apply, because Money Laundering Act would come into effect only when the money is proceeds of crime. Therefore, the proposition which emerges is that the question to evade a tax does not come into the picture at all. The question of evade tax came into the other two earlier against the black money, the Benami. Here there is no question of evasion of tax. The question is whether the evasion of tax ultimately resulted into and ultimately brought about crime proceeds. Now, in this connection, two things are important. Number one, proceeds of crime is defined in section 2U. It is a descriptive definition. It says that the proceeds of crime are directly, indirectly connected with certain crimes which are laid down in the schedule. Then the schedule is specified in section 4. There are 3 schedules. Schedule A with 28 paragraphs. Schedule B, where the amount exceeds 1 crore. And Schedule C, which deals with trans-border transactions. Schedule A, I would like to touch it for a minute. There it points out various acts. Proceeds are from crime, Indian Penal Code, narcotics, drugs, explosives, trafficking, prostitution, corruption, etc. Full list is there. So therefore, the whole ultimate bottom line is what? The bottom line is this should be proceeds of crime in order to attract money laundering. If it is just evasion of tax per se, the Money Laundering Act would not apply. In this connection, let me now come straight away to the case laws. Other commentaries, but I have lack of time, so let me deal with just some few case laws. The first case law I would like to deal with is case law where a person introduced huge sums of high denomination notes in the bank account. 38.53 crores were deposited in the bank account in demonetized notes. The modus operandi was that after there was a person, the person had huge amount of demonetized notes. He deposited in the bank account 38.53 crores. The modus operandi was to deposit the notes, thereafter took fictitious name demand drafts in smaller denominations, later on got it cancelled, tried to convert the demonetized money into monetized money, for a commission. He was arrested after a raid took place and lot of money, including 2,000 rupees notes, were found. He applied for a bail in the Sessions Court. The Sessions Court rejected his application for bail. The matter came up before the High Court. The High Court rejected the bail application on the ground that there is inexplicable silence and reluctance on the part of the plaintiff to adduce proper evidence regarding the nature and the source of funds. So the nature and the source of funds were not explained. The High Court therefore held that the legal presumption arises. See, the point is, under the Money Laundering Act, a legal presumption arises that the money is proceeds from crime. And the High Court held that he has not been able to discharge the onus of proof that the money is proceeds of crime, that he has acquired it, put to use for him, and the voluminous transaction shows, and that beyond doubt, a presumption whether the money were proceeds of crime is not discharged by him. The bail was rejected. The matter traveled to the Supreme Court. The Supreme Court, in this judgment of Rohit Tandon versus Enforcement Directorate, 86taxman.com, page 260. 86taxman.com, page 260, Supreme Court. Rohit Tandon's case, Supreme Court said the ratio laid down by the Sessions Court and by the High Court is absolutely correct. There is a legal presumption that the proceeds were proceeds of crime. In this case, the plaintiff has not been able to establish at any stage that the monies were not proceeds of crime. No evidence as to the nature, as to the source, as to how the funds were procured, how the funds were utilized was not given. And therefore, in Rohit Tandon's case, 86taxman.com, 260 Supreme Court, the bail application was rejected. The second case that I would like to deal with is the case where a person and a group of persons were charged under Section 3, made punishable under Section 4. This is the basic point in all money laundering case, that the charge is under Section 3. Thereafter, you are charged under Section 4. You must fall under Section 3 parameters and then come to Section 4, which has connection with the scheduled offenses. In this case, the Supreme Court analyzed Section 3, which is the heart of the entire Money Laundering Act. The Supreme Court said that Section 3 of the Money Laundering Act is a descriptive section. It describes. It is a descriptive section which describes the offense of money laundering by stating that any person, whosoever, directly or indirectly, attempts to induce or knowingly attempts or knowingly is a party or is interested in any action or activity which may result in proceeds of crime for acquisition, use, confiscation of the money and the proceeds, and projecting the same as untainted money. The Supreme Court has analyzed step by step the entire definition of Section 3 and laid down the criteria, which I think is this is not a Supreme Court judgment, the Gujarat High Court judgment, which lays down the criteria. The criteria is that if you fall within the periphery of Section 3, then only the Money Laundering Act would apply, and consequently Section 4, otherwise it will not apply. It then says that the legislative intent is also spelled out in Section 24, whereby there is attachment and subsequent confiscation. It pointed out that there is a legal presumption. The legal presumption is that the monies are proceeds of crime, and that the proceeds of crime which are there has to be established beyond doubt whether the person is charged or is not charged of the offense. So the basis is the real criteria of proceeds of crime. The legal presumption has to be established, and even if a person is charged or not charged, it has to be done in that particular manner. This is a case of the Gujarat High Court in the case of Jafar Muhammad versus Deputy Director. And this is reported in 353 ELT, Excise Law Times, 353 ELT, page 55, Gujarat High Court. Jafar Bhai Muhammad and a group of people were lucky enough to have lot of unaccounted demonetized money flowing in their bank accounts. However, they could not take it, but they were all caught and arrested. The Gujarat High Court came to the conclusion that, see, all these persons, first of all, are not aware that the money belongs to them. Number two, they have never projected with anybody that these are proceeds of crime and therefore they are to be passed off as untainted money. All that these persons do not know the source. Department has not been able to establish any linkage of them with the demonetized money coming into the bank account, and therefore in all the group cases, the Gujarat High Court in Jafar Muhammad versus Deputy Director cancelled the application of the department in all these cases on the demonetized currencies. I now come, because of shortage of time, one last case which I would like to deal with it. And the last case I'm dealing it is the case of Satish Estates Private Limited versus of Enforcement, and this is reported in 363 ELT, Excise Law Times, 353 ELT, page 21, decision of the Punjab and Haryana High Court. Long facts, long judgment, but I'll split it out for you in a very short way. First stage, S Private Limited entered into a contract with TIL for sale of land. So S sold the land to TIL, but before that an agreement was entered into and earnest money was paid for 25 lakhs of rupees. After some time, TIL filed a case against S Limited for under section 420 on cheating, on the ground that the contract is fraud. The matter traveled, but ultimately the point was that S Limited, the assessee in this case, was entitled to retain that amount as forfeiture amount was given to the S Limited. It's part A. Part B. That company TIL entered into another contract for a different land with a third party. This contract for sale of land by TIL to a third party was worth 3.63 crores, of which 11 lakhs were paid as earnest money. The balance 3.50 crores was paid subsequently. However, the third party filed a case against TIL. In the first case, TIL had filed a case against S, but here the third party filed a case against TIL on the grounds of Section 420, cheating, Section 467 and 468, forged documents, and 471, using forged documents as genuine documents. So there was this dispute. The matter was pending. I come to the part 3, part C of the judgment. The part C on the facts and the judgment is that in this case, the Directorate Enforcement said that, see, here there is a case where TIL has invoked the provisions of the Indian Penal Code against, the third party has invoked the provisions of Indian Penal Code against TIL. It has given the money. Money has come to the account of TIL. TIL has given the advance of 25 lakhs, which was forfeited by S Limited. Therefore, this is all tainted money. And therefore, he invoked the PMLA Act, issued notice to S Limited, Private Limited, and S Limited was brought into the trap of the Money Laundering Act on the ground that the monies which it had forfeited, and it had converted that forfeited money into a fixed deposit receipt, that was attached. A writ petition was filed in the Punjab and Haryana High Court by Satish Limited. The Punjab and Haryana High Court stated the following. Number one, the Enforcement Directorate has filed the complaint against a director, not against the company. The amount has been received by the company and not by not by S Limited. Therefore, it says the very maintainability of the suit is at stake. Point number two. The Punjab and Haryana High Court said that the land in question, which was sought to be sold by S to TIL, is a totally different land than the land which is purported to be sold by TIL to a third party. There is no connection between the two lands. Therefore, you cannot say that that money has any connection. Third issue, that at no stage whatsoever any cogent evidence or trail was pointed out by the Enforcement Directorate that the money which was paid to TIL in fact traveled to S Limited. Under these circumstances, the Punjab and Haryana High Court came to the conclusion that you cannot say that these are proceeds of crime. If these are not proceeds of crime, then the question of the trail not being given, the Money Laundering Act would not apply. I had some few other points, but I think so. Dharan, I think this is enough. I don't know the time. Yeah, it's nearing 1:30. I would now, I think that I have made an attempt on the 3 acts. I would be closing by putting in a few acknowledgements. I think all these things would not have been possible but for my brainstorming session with Dharan Gandhi. It would also not have been possible without the support of Shivram, Dr. Shivram and his juniors in the case laws. to Satish Bafna, Chartered Accountant who assisted me in the Black Monies Act, also to a very senior Chartered Accountant, R.V. Shah, who assisted me, and finally, Gautam Thakkar, advocate, also assisted me. Let me tell you, it has been a very, very tiring and a difficult task to bring in all the three acts together. You got confused. I was really diffident in doing it. In fact, I had refused on this very topic earlier. Now I had the courage because Dharan persisted, insisted, and therefore we are going ahead. I think these confluence of these three acts is the same as the tributaries falling in the Ganges, and let it flow in a right direction. Thank you.